Hello, welcome back everyone to Poli-Sci 110 American Government and Politics. This lecture will examine some dilemmas in freedom, particularly with regard to the First Amendment freedom of speech. Whenever I talk about dilemmas of freedom, I'm talking about a trade-off between freedom, equality, and order. Even though Americans are guaranteed particular civil liberties within the Bill of Rights, that is the first 10 amendments to the US Constitution, often those freedoms may come at a cost to order or equality. Tough decisions have to be made about how willing we are to guarantee the freedom of speech, or if there are any limits regarding the freedom of speech. Former President Barack Obama provided a quotation that really summarizes this idea nicely. You can't have 100% security and then have 100% privacy and zero inconvenience. We're going to have to make some tough choices as a society. What he was referring to was surveillance of individuals in order to prevent terrorist activities. That involves a trade-off between security and privacy as well. The freedom of privacy can often come at a cost to order. The way that is related is this. If there is an attack, then that would actually reduce order within society. Attacks are disorderly. And so in order to try to achieve that right balance, the president is saying there's going to have to be some tough decisions about how much surveillance or security we want in order to preserve order, even though it may infringe on the freedom of privacy somewhat. We're not going to talk a whole lot about privacy here today, but we will talk about freedom of speech, an issue that generates almost comparable levels of fervor or interest among the American people. So for example, what would be some trade-offs between order and freedom with regard to freedom of speech? Is screaming fire in a crowded movie theater a good idea? Doing so would definitely jeopardize order. People would run out of the room. Are universities banning hate speech a good idea? Could there be possibly violence on university campuses if hate speech was not banned? Can the government keep track of phone records as well? Is this a dilemma regarding order and freedom? Can the government stop publication of news stories? Can people own bazooka guns and tanks? Some of these go beyond the First Amendment, as you might have noticed already. Particularly this last issue pertains to the Second Amendment, right to bear arms by citizen militias. However, during this lecture, we're going to focus on the freedom of speech. But the overall point here is that balancing freedom and order often involves decades of tough questions and decisions. The dilemma of freedom is that liberties and rights may also conflict with each other. Your right to scream fire in a crowded movie theater interferes with the right of other people to watch a theater peacefully, for example. So let's start with a little bit of background information about selective incorporation and the protection of civil liberties. Initially, state governments were actually not bound by the Bill of Rights. It was perfectly feasible for state governments to jeopardize or threaten civil liberties outlined within those first 10 amendments to the US Constitution. What this means more specifically is that it was the federal or national government, Congress, that had to obey or protect those civil liberties. States could violate those fundamental rights. For example, states could restrict free speech and did so even into the early 20th century. At the bottom of this slide, I have an example of a farmer who did not buy Liberty bonds during the First World War. And when he was confronted by a mob of people from the small town, he made some derogatory comments regarding the American flag. And as a result, he was convicted for violating a Montana law that prohibited those kinds of comments about the American flag. And he was sentenced to prison and hard labor. That's an example of a state violating the free speech. And ultimately, the US Supreme Court did rule that states cannot limit that sort of speech. Not in this particular case, but years later. The adoption of the 14th Amendment to the US Supreme Court did allow the US Supreme Court to begin incorporating or applying the Bill of Rights to the states. And so over time, over 150 years and counting, the US Supreme Court has issued various opinions in which it has deemed that state governments cannot ban or prohibit or jeopardize civil liberties outlined across the Bill of Rights. In particular, the Due Process Clause of the 14th Amendment ruled that no state shall deprive any person of life, liberty, or property without due process of law. And so this due process clause has allowed the US Supreme Court to apply the Bill of Rights to the state governments and deem that those state governments cannot infringe on civil liberties. Importantly, this process is known as selective incorporation, meaning that as cases come before the court, say, for example, a case involving a state law that prohibits the free exercise of religion, as those cases come to the court would issue a ruling that the states cannot violate that civil liberty in the Bill of Rights. And so in the example, if a state is violating the free exercise of religion, the court would rule that states cannot violate that civil liberty. But when is it legal to violate civil liberties? So the Supreme Court, through selective incorporation, which began in 1897 and continues, has applied the Bill of Rights or incorporated the states under the Bill of Rights over years, and it has outlined particular amendments that the states cannot threaten, or civil liberties that the states cannot threaten. In particular, at present, the states must respect liberties in the First, Second, Fourth, Fifth, Sixth, and Eighth Amendments. One of the most recent amendments to be incorporated was the Second Amendment, as recently as the late 2000s. This is the right to bear arms. The Supreme Court has ruled in two different cases from 2008 and 2010 that state governments have faced limits in terms of infringing on the rights of handgun ownership. In one case involved the city of Chicago, and cities are treated legally as entities or extensions of the state governments. However, it remains to be seen, or it remains to be incorporated, state governments are yet not required to use juries in many trials, and they may levy large fines as opposed to the federal government, which has certain limits in terms of fines. And so states may violate liberties as well, only if there's a compelling interest as deemed by the court. In particular, what this means is that a state government can argue that a certain law that it has enacted is constitutional, perfectly fine, even though it may violate a liberty, only under two circumstances. The court will allow two arguments for the state. The first is there a good reason for the law? So is there a compelling state interest in having a law that violates a civil liberty in the Bill of Rights? But second, is the law written in such a way to be the least intrusive possible or to maximize liberty? So in other words, are there other ways for the state to achieve its compelling interests or its ultimate goal? Could it pass another law that would be less intrusive of liberty and yet achieve the same compelling state interest or the same goal? Ultimately, in solving these dilemmas, a lot of these tough questions have had to be settled at the judicial level or within the courts. Judges often help to solve these questions by delivering a consistent set of rulings over time, particularly by relying on precedent. That is what former cases have said or indicated in the past. And the framers of the US Constitution saw the courts as a major means for protecting civil liberties because these types of liberties or actions would not be protected by legislatures or elected governors or presidents, because those legislatures and governors would respond to political majorities or majorities of voters. And so it's often your political minorities who want to seek protection for particular civil liberties. And so in the case of Montana, a majority of voters may have been perfectly fine with a law that limited desecration of the flag or prohibited derogatory speech of the American flag. However, there was that one farmer who I mentioned earlier in the lecture who obviously would have objected to that law given the comments that he made. The court itself, the US Supreme Court, has varied or fluctuated over time in just how open it is to civil liberties, but it's generally remained consistently moderately liberal or conservative, really middle of the road, I guess would be a better way of phrasing it, since the 1970s or so in terms of civil liberties cases. So what is and isn't free speech today based on court decisions? So there are curbs on free speech or limits. Not all speech is protected under the First Amendment. For example, advocacy for unlawful activities is not protected. The court applies a clear and present danger standing to deciding these kinds of cases. To give you an example, in 2007, there was a teenager or a high school student in Alaska who waved a banner in his hometown that read "Bomb Hits for Jesus." And this banner was waved as the Olympic torch was ran through the town by an athlete. This attracted a lot of news coverage, and the high school, I think, punished the student as well. This case went all the way to the US Supreme Court, and ultimately the court ruled that the student could be suspended because this was advocacy for an unlawful act, or at least it was unlawful at that time. Also, fighting words and hate speech are not protected under the Constitution. Fighting words are directed at individuals, and hate speech is directed at groups, even though the substance may be somewhat similar. Symbolic speech is not protected, such as banners or burning things. The regulation, however, that prevents such symbolic speech has to be content neutral. And finally, states are able to put limits on the time, place, and manner of speech that are, as long as those limits are within reason or do not unjustly burden those who want to express themselves. Free speech has become a very hot topic on university campuses these days, particularly before COVID caused people to go inside and social distance. To give you some more information about this issue, private universities can regulate speech on campus, but it's really public universities where a lot of legal cases emerge simply because public universities are treated as extensions of state governments. And as a result, they are subject to the limits that the Supreme Court places on state governments. And so try to imagine Arizona State University is an extension of the state government of Arizona. It is, after all, Arizona State University. So far, more than 350 or so universities have adopted something called speech codes that limit speech in different ways. Many of these are private universities that do not have to respond to a court per se in choosing to limit speech. It's often intended, these speech codes are often intended to curb hate speech, but sometimes they do run into legal issues over free speech. We've seen some very prominent examples of universities and free speech controversy, particularly with such controversial speakers like Richard Spencer or even Ben Shapiro. The questions often involve whether universities should have to support the security costs for these particularly controversial speakers. What we have seen is that some public universities have adopted speech codes that have run into constitutional issues. So for example, a public university, the University of Michigan, back in 1988, adopted a speech code that prohibited any behavior, verbal or physical, that stigmatizes or victimizes an individual on the basis of race, ethnicity, religion, sex, orientation, creed, or creates an environmental, intimidating, hostile, or demeaning environment. This seems really harmless and it seems helpful, but it was ultimately struck down by a federal court just a year or so later. And the court recognized that it is an unfortunate fact of our constitutional system that the ideals of freedom and equality are often in conflict. The difficult and sometimes painful task of our political and legal institutions is to mediate the appropriate balance between these two competing visions. As for the Arizona State University, ASU does not have an official speech code, and we are the largest university in the United States with a green rating from the Foundation for Individual Rights in Education, an organization that is very much pro free speech on university campuses nationwide. And the ASU has adopted a University of Chicago policy, which is to say free speech is perfectly fine so long as it does not interfere with the functioning of the university. And during non-COVID years, hopefully soon, in the future as well, you will find that there are many demonstrators or political proselytizers, I suppose that might be the word, in front of the ASU Memorial Union. Very rarely have I heard of violence in front of the union, though. It's typically all just social activity, but never anything violent from what I could tell since being here. So what about the Federal Communications Commission? What is the ruling on that? You might recall from the very first lecture in this course that there was a famous singer named Bono from Ireland who received an award on television back in the early 2000s, and he used an expletive. What the US Supreme Court has allowed is for the Federal Communications Commission to regulate the content of broadcast television. But this does not apply to satellite or any sort of subscription services. So subscription radio, Sirius XM, stuff like that, satellite, those are not limited by the FCC. But the type of free television that you can pick up, as well as free radio, those are regulated by the FCC. And in particular, those regulations, those word choices, the limited words, those limits are banned from 6 a.m. until 10 p.m. The interest here is in protecting children who may be listening at that time. And so the dilemmas of freedom involve often a trade-off between personal freedom and order. And so over years, many tough questions have been resolved, typically by courts, sometimes by legislatures. And so in terms of the future of free speech, I will leave a lot of tough questions to your discretion as well.